Welcome to our practice exercise debrief, where we're going to be applying the elements of 18 U.S.C. Section 207A2 to the proposed post-employment activities of a hypothetical employee. And our hypothetical employee is Ken Dickens, who serves as a supervisory counsel at FDA. We're going to be using this worksheet to apply the elements of A2 and quite possibly A1 as well to Ken's proposed post-employment activities. We'll be making reference to the implementing regulation at 5 CFR Part 2641, as well as to the preamble to the final rule. And we will be using some excerpts from the summary of 2641, but I would advise you that when you are actually providing advice and counsel to real employees about their proposed post-employment activities, that you rely exclusively on the actual language of the regulation itself. So let's begin our practice exercise. We're going to begin with what is effectively an academic question, which is Ken an employee for purposes of the application of 207? The definition of employee for these purposes is that it extends to all federal executive branch employees except the president, the vice president, and enlisted military personnel. So the answer is yes, Ken is an employee. Were there any specific party matters that were pending under Ken's official responsibility? Here is where A2 departs from A1, in that while it still is focused on the specific party matters that Ken had under his official responsibility, it's not focusing on whether or not Ken personally and substantially participated in them. That's the A1 restriction. So we'll be looking at whether or not there are specific party matters that were actually pending under Ken's official responsibility during his last year before terminating from government service. So Ken has helpfully given us a post-employment checklist where he has outlined for us generally what his duties have been, which have included supervising staff in drafting regulations, but also in supervising staff in providing legal support to consumer safety officers and the compliance division in connection with their activities such as monitoring, auditing, and investigations. He has also very helpfully given us a specific matter that his staff has engaged in that actually we're going to be focusing on almost exclusively because it is directly related to the company that he has identified as being his prospective employer, which is wellness. So we have to begin then by asking ourselves whether any of these duties that Ken has described would qualify as specific party matters. So as we discussed in the A1 debrief, a specific party matter is effectively any matter that has identified or named parties. Now, that can arise in the context of specific types of proceedings, like judicial proceedings, administrative adjudications, court cases, litigation generally. But it also can be a factor in transactional types of matters, which would include things like contracts, grants, licenses, applications, product approvals, and enforcement actions or oversight types of actions such as monitoring, auditing, and investigations. So based on our definition of specific party matter, it is clearly the case that Ken's staff at the very least have been participating in specific party matters. Again, the one that we are most concerned about is the one that is most directly related to his proposed post-employment. Ken has said that he's proposing to go work for Wellness, which is a pharmaceutical company, and that company was the party to a compliance investigation where Ken's staff provided legal support. So now we have the question of whether or not it was actually pending under Ken's official responsibility during his last year of government service. And for purposes of discussing actually pending under official responsibility, I have been using a shorthand when it comes to A2 by saying A2 only applies to supervisors and managers. And if you look at the definition of official responsibility, you'll understand why that shorthand is appropriate. Official responsibility means the direct administrative or operating authority, whether intermediate or final, and either exercisable alone or with others, and either personally or through subordinates, to approve, disapprove, or otherwise direct government action. So in order to be able to have official responsibility as this is defined, you have to have official authority to direct the actions of, for example, subordinates. So that is why I use as a shorthand that A2 is really only going to apply to supervisors and managers because they are the only ones who actually have official authority to direct the actions of others. Now, there is, in the third bullet point there is a definition that often gives people a sort of a hair fire, which is all particular matters under consideration in an agency are under the official responsibility of the agency head, and each is under that of any intermediate supervisor who supervises a person, including a subordinate, who actually participates in the matter or who has been assigned to participate in the matter within the scope of his official duties. Now, what that is saying is that it is theoretically the head of the agency will have an A2 restriction with absolutely everything that is pending in the agency. Similarly, the farther up in the chain of command you are, the more matters you will ostensibly have and be responsible for with respect to an A2 restriction under your official responsibility. As a practical matter, there is a knowledge of official responsibility aspect to 207A2. It is something that we typically don't discuss in our training sessions because we are interested in giving prospective advice. And the knowledge element is something that would most likely be a factor that would be determined if, for example, the Department of Justice were to decide whether or not to prosecute someone for having violated 207A2. And the knowledge element is that the employee at the time of their appearance or communication post-employment knew or reasonably should have known that the matter had been pending under their official responsibility during their last year of government service. So while the statute is in effect giving employees at higher levels of responsibility an enormous number of matters that they're going to be effectively held accountable for in an A2 restriction, it's only going to be limited to those that were pending during their last year of government service. But there is a knowledge element that does on some level mitigate the likelihood that an agency head or a former agency head or a former senior employee would have an A2 violation for something that happened several layers down in their chain of command. So what does actually pending mean? A matter is actually pending under an employee's official responsibility if it's been referred to them for assignment. So whenever Ken, as legal counsel, is given an assignment that his staff is supposed to take care of and he has full cognizance of that matter, that will be something that's pending under his official responsibility. But it also includes any matter that has been referred to or is under consideration by any person he supervises, including a subordinate. So in the case of being a legal counsel, obviously other parts of FDA come to legal counsel for their legal support. So while the legal counsel may not have complete cognizance over the entirety of certain matters from beginning to end, they play a role in those processes. And while those matters have been brought into their chain of command, that for their service, whatever the service is that they're providing, in this case it's legal support, that those matters are pending under Ken's official responsibility because they are assigned to his staff and he has official responsibility for that work while his subordinates are required to be working on those matters. A matter remains pending even when it is not under active consideration, and there's no requirement that the matter must have been pending under the employee's official responsibility for a certain length of time. So these are all things that once something comes into Ken's chain of command and is being considered by himself or his subordinates, that matter is pending, whether it was for a day or for a year, whether it's being acted upon or whether it's not being acted upon. Two additional points I'd like to make about this before we move forward is that actually pending is not affected by leave status. So if, for example, Ken were to take a month's worth of leave for whatever reason, matters that were assigned into his chain of command while he was on leave, he would still be deemed to have official responsibility for those matters, notwithstanding that he wasn't physically present or was in leave status when those matters came in. Similarly, and perhaps more importantly, Ken cannot disqualify himself out of an A2 restriction for any matters that are under his cognizance. So if for whatever reason Ken wanted to recuse himself from a specific legal review, for example, and that he was going to do it either by asking one of his deputies to do the supervision, or even if he were to send it up the chain to one of his superiors to do the supervision in his stead, that matter is still pending under his official responsibility because it is still within his line of authority and his chain of command. So you cannot disqualify yourself out of an A2 restriction. So we've talked about, we think that clearly this is a specific party matter, this investigation. Clearly his staff was engaged in the legal review of providing legal review support to this investigation. So I think it's clear that on that basis, it appears as though this was pending under Ken's official responsibility. But we have that additional piece, which is it had to have been pending during his last year before terminating from government service. Now, Ken has not left service yet. His proposed termination date that he gave us on his checklist was October 1st of 2020. So what we would have to do is to do a 1-year look back from October 1st of 2020 back to October 1st of 2019. And if this investigation was pending in his chain of command under his official responsibility at any time during that 1-year period, then it would be deemed to be pending under his official responsibility and he would have an A2 restriction with respect to it. Now, as we mentioned when we were doing our A1 debrief, the critical distinction when you're providing advice and counsel to supervisors and managers is we want to be perfectly clear with them about the distinction between something merely pending under your official responsibility and something for which you actually participated personally and substantially. Because to participate personally and substantially includes matters where the employee has engaged in direct and active supervision of a subordinate. So a supervisor may very well have participated personally and substantially and not just had something pending under his official responsibility. So we are going to have to get more information about the nature of Ken's involvement in the matter. We need to find out, did he participate personally and substantially in the legal review support that was provided in connection with this compliance investigation? So again, going back to the definition of personal and substantial participation, to participate personally is to participate directly, and in the case of a supervisor, it's to actively supervise the work of your subordinates. To participate substantially, again, can include direct and active supervision of subordinates. So we're looking at what was the nature of Ken's supervision. Did Ken do status checks on the legal review? Did he review drafts of the legal support? To the extent that Ken engaged in any of those activities, he not only likely directly and actively supervised, but he may himself have participated personally and substantially in that matter by approving, disapproving, by making recommendations or rendering advice that rose to the substantive merits of the matter. So we do have a question mark right now. This is additional information we would have to ascertain from Ken. But as it stands right now, it looks as though Ken may very well have an A1 restriction with respect to this compliance investigation. And that's very important because, as you will remember, the lifetime of the matter is the length of time for which Ken would have a restriction under A1. It's a lifetime bar, as opposed to matters that are only pending under Ken's official responsibility that are subject to the A2 restriction only have a 2-year bar that begins to toll from the date that he would terminate senior service, terminate government service. So what about regulatory matters that Ken and his staff worked on? We've talked about this investigation, but we've ignored completely the fact that a goodly part of the work that Ken did, evidently, or does, is to draft regulations. 2641.201H2 states explicitly, so if you're looking for where the regulation tells you this, matters of general applicability are not covered for purposes of A1 and A2. The only matters that are covered by A1 and A2 are specific party matters. And matters of general applicability include things like legislation, rulemaking, general policies, things of that ilk. Regulations, generally speaking, are not going to be specific party matters, and therefore Ken is not going to experience any restrictions with respect to any post-employment activities that he would engage in that would involve communicating back to the government in connection with any and all of the regulations that Ken and or his staff may have worked on. So now let's look at the post-employment activities that Ken is contemplating and talk about whether and to what extent he will have post-employment restrictions with respect to those activities. We want to start with what is an appearance or communication, because the bar that Ken's going to have under A2, which is the same as it is under A1, is a representational bar. So what is an appearance or a communication? An appearance is, as was the same in our A1 debrief, an appearance is your mere physical presence before an employee of the United States. It can be in a formal or informal setting, and it can be in circumstances where you are literally simply appearing, where if the totality of the circumstances indicate that there's some intent to influence, simply appearing without doing anything further can at times be restricted under both A1 and A2, and we're going to talk about that a little bit more later on. A communication is self-evident. It is imparting information or requesting information or effectively just generally communicating and or in writing. Again, it can be formal or informal. And we have this aspect, which is this intent that information be attributed to the former employee, which is a third-party intermediary concept that I'm going to touch on in a moment, because it's going to, in some respects, blur the distinction between behind-the-scenes assistance and an actual prohibited communication. So behind the scenes assistance is permitted as long as there is no, as we say here under communication, intent that the information be attributed to the former employee. So when we look at the definition of behind the scenes, this is what we say in the regulations behind the scenes means. Behind the scenes assistance, we say, nothing in this section prohibits a former employee from providing assistance to another person, provided that the assistance does not involve a communication to or an appearance before an employee of the United States. And then we give you an example in the regulation. It's example 3 to paragraph D. And this is to sort of illuminate a little bit what we mean by what would constitute behind the scenes assistance, permitted behind the scenes assistance. We say there's a government employee who administered a particular contract for agricultural research with Q Company. When she terminated, she went to work for Q Company pretty much on the same matter, but she had no direct contact with the government in connection with this matter. Her company asked her to prepare a paper that would describe the people in her agency who should be contacted and what they should say to them in an effort to increase the scope of funding for the contract and to resolve favorably a dispute over a contract clause. And we say in this example that she may do so. So the critical piece here is that she's confining herself entirely to behind the scenes, that she can provide critical information to people about the same matter that she worked on as long as she confines herself to behind the scenes. So where this gets a little, I won't say fuzzy, but I will say it gets a little more complicated, is once we introduce the concept of third-party intermediary. You can read about this in the preamble to the final rule under the section dealing with communication and appearance, but it's illustrated in example 5 to paragraph D. And this example is taken explicitly from an Office of Legal Counsel opinion that was issued back in 2001. And what the Office of Legal Counsel opinion dealt with was a circumstance where a former senior employee had created a consulting firm after they terminated service. The consulting firm wrote a report for one of its clients. That client shared that report or submitted that report to the former senior employee's former agency. And the totality of the circumstances indicated that the former senior employee fully intended to be recognized by their former agency as the source of the information in that report. So the OLC opinion concluded that former employees should not be permitted to engage in indirect communications that would otherwise be in violation of their representation bar by using third parties to do the communicating on their behalf, particularly where it appears through the totality of the circumstances that the former employee intends to be recognized, intends to have the communication attributed to them. It's third party as subterfuge for the most part is what we're discussing here. And this is when we're rendering advice to employees about engaging in behind the scenes assistance, it is imperative that we talk to them about making certain that they confine themselves to behind the scenes and that they don't do anything to either direct or encourage the people who will be communicating back to the government to invoke their name or to in any way make it appear as if they are intending to have that information attributed to themselves. So let's think a minute about what Ken is proposing to do for his future employer and talk a little bit about whether or not he may make communications and connections with some of those activities. So in conjunction with his regulatory work that he will be doing for wellness, may Ken communicate with FDA or HHS about the regulations that he and his staff worked on while he was an employee? And the answer is yes, he may. As we mentioned earlier, regulations, generally speaking, are not specific party matters, and so an A1 or A2 restriction is not going to reach to any matters of what we call of general applicability that Ken and his staff may have worked on. May Ken submit comments on behalf of wellness on new regulations HHS issues. Again, regulations are not specific party matters, and so Ken will have no restrictions with respect to making comments back to HHS on new regulations that they may issue, and he may do so on behalf of wellness. So may Ken communicate with government auditors and investigators about the wellness compliance program. Now notice here we're talking about the wellness compliance program, not the wellness compliance investigation. So this is where it's important to remember how narrow the restriction is under A2 and A1. Ken is only restricted as to communications or appearances made with the intent to influence back before the government in connection with specific party matters in which he either participated personally and substantially or that he had pending under his official responsibility during his last year of government service. So in this case, the only thing he's going to be restricted with respect to communicating back to the government on behalf of wellness is the compliance investigation. New investigations, he can be the point of contact. Anything that's unrelated to the investigation, he can be the point of contact. So his restriction is actually quite narrow. So when is there an intent to influence? Intent to influence is conjunctive with communication or appearance. So Ken's going to be barred as to any communications or appearances where he is seeking a government ruling, a government benefit, an approval, or other discretionary action. And discretionary action is really the critical language here. Anytime you're asking the government to engage in some sort of discretionary decision-making about what they're going to share with you, what they're going to do for you, information they're going to make available to you, anything of that ilk, you're looking at an intent to influence. Also, if he's seeking to affect government action where there's a real or potential dispute or controversy, again, an adversarial type of circumstance, communications that are made in connection with that type of matter are typically going to be communications with the intent to influence. So when you think about an investigation is typically a fairly adversarial type of matter. So Ken is going to have to exercise an enormous amount of caution, and I would argue be advised, frankly, not to make any communications back to the government in connection with that investigation, even if arguably one might say they are deemed to fall within the ambit of this next list of not intent to influence. Now, a social visit with former coworkers, we've talked about this before. A social visit means not the venue. It's not that once you're in a social venue, all bets are off and you can talk about anything you want to with your coworkers. That's not what this means. This basically means that you're not prohibited from having visits with people that you used to know, but you cannot be making communications on behalf of your employer or on behalf of anybody else that would otherwise be prohibited communications if you were to be attending a meeting, for example. It's not an intent to influence to convey or request purely factual information. We're going to address this in a second by looking at two examples in the regulation that help to further flesh that out, or to request publicly available documents. So let's just move on to these two examples that I've pulled from intent to influence, because I think that they will help us clarify when it is that an employee can request purely factual information and have it really not be an intent to influence, and when the circumstances might in fact indicate otherwise. Our first example is example 3 to paragraph E2. And in this example, we have a former DoD employee. They're now working for a firm that has a contract with DoD to produce an operator's manual for a radar device. And in the course of developing a chapter about certain technical features of the device, this former employee asked the DoD official certain, what we're characterizing in the example as factual questions about the device and its properties. and the discussion doesn't concern any matter that's known to involve a potential controversy between the agency and the contractor. So we conclude that the former employee has not made a communication with the intent to influence. Notice here how important it is that we did not stipulate as to what the factual questions were. The important piece here was you look at the context in which the questions are being asked with a view to what the former employee is trying to achieve by asking those questions. And in this case, we argue that writing an operational manual for a device and asking technical questions about how the device functions does not appear to be a circumstance in which there's any degree of controversy or adversarialness. So in that context, we argue there is no intent to influence. Now contrast that with example 4 to paragraph E2. A former medical officer of the FDA sends a letter to the agency in which he sets out certain data from safety and efficacy tests on a new drug for which his employer is seeking FDA approval. Even if the letter is confined to arguably factual matters, such as synopses of data from clinical trials, the communication is made for the purpose of obtaining discretionary government action, approval of a new drug. Therefore, this is a communication made with the intent to influence. So the point here is we do not want to get lost in the weeds of arguing about what is or isn't, or what could or couldn't constitute factual information either being provided or factual information being requested. We want to look at the circumstances in which it's either being requested or provided and what the intentionality of that set of information is and whether it is connected to anything in which the government, there is some degree of controversy, some degree of adversarialness, and whether ultimately the goal is to influence the government in a certain direction. So what if Ken attends a meeting, but he doesn't speak? So here we're going to come back to the thing that I dropped in your lap when we were talking about appearance, a mere physical presence, an appearance being made with the intent to influence. This is at 2641.201E4. And it says, under some circumstances, a former employee's mere physical presence without any communication by the employee concerning any material issue or otherwise may constitute an appearance with the intent to influence an employee of the United States. And then we go on to give relevant considerations and factors to consider when determining whether or not an employee's mere appearance would be sufficient to constitute an intent to influence. We're not going to talk about those factors today because they are going to be very, very fact specific, and they're going to be dependent upon the specific situation that your employee finds themselves in. So this is a determination that is likely only ever going to be made in a post-employment context where an employee is contemplating attending a meeting or some other function where and in connection with something over which they otherwise would have a post-employment representational bar. So on whose behalf might Ken be making the appearance or communication? So Ken is prohibited from making communications and appearances on behalf of another person. He is not prohibited from making self-representations, but it has to be on behalf of any other person. This is the same as it is for A1. Any other person includes both human persons, individuals, as well as legal persons, so companies and institutions and state, local, and foreign governments, and obviously the employees or agents thereof. And it would include if, for example, Ken were to leave government service and decide to create, for example, his own consulting firm, and he decided to incorporate that by making it an LLC or an S Corp or through some other legal vehicle, he will have created legally speaking, a third person. And so anytime he was making any communications back to the government on behalf of his company, he would be doing so on behalf of another person. But what does it mean to act on behalf of? Like, how do you establish the agency to actually be acting on behalf of this third party? Well, if you're formally their agent or their attorney, then clearly you're acting with agency. But there's also a less formal way in which you can be acting with agency, and that is if you are acting with the expressed or implied consent and subject to some degree of control or direction by the other party. So in the preamble to the final rule in the Federal Register, when it comes to acting on behalf or communicating on behalf of your employer, OGE has taken the position that effectively anytime a former employee is acting as an employee of their employer, they are acting on behalf of their employer. So for Ken's purposes, once Ken begins working for Wellness, anytime he is acting, making a communication or appearance as an employee of Wellness, while he's being paid by Wellness, as part of the duties that he's been assigned by Wellness, he will be deemed to be making those communications or appearances. He will be deemed to be acting on behalf of Wellness. So the question presents itself, well, when might Ken be deemed to be representing himself? Now, in example 3 to paragraph G, we have an example, I think, that helps to illustrate when someone might actually be acting on their own behalf. And it says that an employee of the Administration for Children and Families wrote the statement of work for a cooperative agreement that was to be issued to study alternative workplace arrangements. He terminates government service and joins a nonprofit group that was formed to promote family togetherness. So then he gets asked by his former agency to attend a meeting in order to offer his recommendations concerning the ranking of the grant applications that he had reviewed while he was still a government employee. So a grant review would be a specific party matter. He would be restricted as to representing back anybody else in connection with those same matters. The management of his nonprofit group agrees to permit him to take leave to attend the meeting in order to present his personal views concerning the ranking of the applications. Although the former employee is a salaried employee of the nonprofit group and his recommendations may be consistent with the group's interests, the circumstances establish that he did not make the communication subject to the control of the group. So this is just to give you a flavor of when and under what circumstances might a former employee be able to speak to their former agency or speak to the government about matters that they worked on while they were a government employee and for which they have post-employment restrictions, but not be deemed to be acting on behalf of another, or specifically their employer. So, whom they cannot appear before or communicate with. Under A2, as was the case with A1, a former employee may not make an appearance or communications or with the intent to influence to or before an employee or officer of any executive branch, department, executive branch, agency, or independent agencies of the legislative or judicial branch, any federal court or courts martial. So are Ken's communications restricted only as to FDA? And clearly the answer is no. We just said that it's all executive branch agencies, including independent agencies of the legislative and judicial branch. It would be any executive branch department and federal courts. So what is the same particular matter? 207A1 and A2 require that when an employee makes the communication or appearance with the intent to influence after government service, that in order for A1 and A2 to bar those communications or appearances, they have to be made in connection with the same particular matter involving specific parties as that which the employee either worked on or had pending under their official responsibility during government service. So this can be a little tricky at times because particular matters have a way of evolving into other iterations of themselves, which is to say, an employee may find themselves being asked to make a communication or appearance in connection with a particular proceeding or in connection with something that seems to address their prior specific party matter in part, but maybe not in whole. So we typically say that it's very difficult to prospectively discuss this other than just to have a general sensibility about whether it's even likely that the employee is going to be working on anything that's even remotely related to the matters that they worked on while they were in government service. But we do give you at least some consideration, some things to be looking at to make a determination whether or not, at the time the employee would wish to make the post-employment communication or appearance, whether or not it's really in connection with the same particular matter involving specific parties. So let's ask and answer this question to sort of clarify what I meant by what I just said, which is, might Ken have any restrictions with respect to any administrative or judicial proceedings, for example, against wellness that might be based upon the findings of the investigation? And again, we have examples in the regulation that at least reach to this. And they're not going to answer every question about this, but that reaches to answering that specific question. Under same specific party matter, this is example 1 to paragraph H4. A government employee participates in an internal agency deliberation concerning the merits of taking enforcement action against a company for certain trade practices. He leaves the government before any charges are filed against the company. He has participated in a particular matter involving specific parties and may not represent another person in connection with the ensuing administrative or judicial proceedings against the company. So in this case, what we're seeing is there are proceedings that extend from the specific party matter in which the employee participated while in government service. So even though those charges were not drawn up while the employee was in government service, the matter that he participated in is the same particular matter involving specific parties as the subject matter of this administrative or judicial proceeding. When is the U.S. a party, or does it have a direct and substantial interest? The U.S. has to either be a party or have a direct and substantial interest, but it does not have to have both. And when we're talking about the United States as a party or having a direct and substantial interest, we are talking about all branches of the United States government. Now, the U.S. does not have to be a party to the matter in order to have a direct and substantial interest in the matter. The matter does not have to be pending in a federal forum for the U.S. to be a party or have a direct and substantial interest. However, the U.S. does not necessarily have an interest in a matter simply because there's a federal statute that's at issue or the matter is pending in a federal court. And that's kind of all we're going to say about whether or not the U.S. is a party or has a direct and substantial interest, because again, that's going to have to be a determination that you make at the time that the post-employment communication or appearance is actually being contemplated, so that you have a full set of facts to operate from. So are there any applicable exceptions? And in this case, we don't see any activities that Ken is discussing that would be the subject of any available exceptions. So in sum, what we've discussed today is we've identified one particular matter involving specific parties that we know for certain is something that was likely either pending under his official responsibilities during his last year of service and or that he participated in personally and substantially. It is critical that we make that determination of whether or not he has an A1 restriction or an A2 restriction or both, because the minute he has an A1 restriction, that effectively trumps A2, and A2 is frankly then moot. So with respect to the activities that he's proposing to engage in for wellness, the regulatory program that he will be responsible for likely is not going to present A1 or A2 restrictions for him unless somehow in the conduct of that regulatory program he's being asked questions or he's having to engage in something that's going to deal with the compliance investigation, which is the specific party matter with which he will have applicable restrictions. Being the point person for their compliance program, again, we need to remember his only restriction is going to be with respect to the wellness compliance investigation. Any and all other aspects of the job that he's going to be asked to engage in are going to be free from A1 or A2 restrictions. His restrictions reach not only to communications with FDA or with HHS, but to all executive branch departments and agencies, and certainly federal courts. And anytime he is communicating anytime he's communicating as an employee of wellness, he is going to be deemed to be communicating on behalf of wellness. And those would be prohibited communications if they are in connection with the compliance investigation. So finally, just to highlight some of the aspects of 207A2 that we've tried to discuss today, is that 207A2 is only going to apply to supervisors and managers, people who have the authority to direct others' actions. It applies for 2 years from the date of termination from government service. It applies only to matters that were pending under the employee's official responsibility during 1 year prior to their termination. It's a 1 year look back. The restrictions otherwise are absolutely identical between A1 and A2. You cannot avoid an A2 restriction through disqualification from a matter, and direct and active supervision means that you have an A1 bar, and an A1 bar will trump A2. Thank you so much for participating in this practice exercise.